Republic v. Court of Appeals, GR number 92326, January 24, 1992. Ponente, Justice Regalado. Facts. On February 2, 1988, respondent Zenaida Kotzebue-Biles filed a petition to adopt Jason Condat, then 6 years old and who had been living with her family since he was 4 months old, before the RTC of Legazpi City. Zenaida is married to Dioscora Biles. RTC granted the petition, which CIA subsequently affirmed. Hence this petition by the OSG. Note: when the petition was filed, applicable law was PD number 603, the Child and Youth Welfare Code. Under said code, a petition for adoption may be filed by either of the spouses or by both of them. After RTC rendered its decision, the Family Code took effect on August 3, 1988. Under the said new law, joint adoption by husband and wife is mandatory. OSG arguments. 1. The Family Code must be applied retroactively to the petition filed by Mrs. Biles, as the latter did not acquire a vested right to adopt Jason Condat by the mere filing of her petition for adoption. Hence, the petition for adoption should be dismissed outright, for it was filed solely by private respondent without joining her husband, in violation of Article 185 of the Family Code, which requires joint adoption by the spouses. 2. Assuming arguendo that the Family Code is not applicable, CIA should have modified the trial court's decision by granting the adoption in favor of private respondent Zenaida Biles only, her husband not being a petitioner. Issue 1 of 2, whether or not the Family Code should be applied retroactively, as no vested rights would be impaired in doing so. Held, no. Under the Child and Youth Welfare Code, respondent had the right to file a petition for adoption by herself, without joining her husband therein. When Mrs. Biles filed her petition, she was exercising her explicit and unconditional right under said law. Upon her filing thereof, her right to file such petition alone and to have the same proceed to final adjudication, in accordance with the law in force at the time, was already vested and cannot be prejudiced or impaired by the enactment of the Family Code. The jurisdiction of the court is determined by the statute in force at the time of the commencement of the action. Such jurisdiction of a court, whether in criminal or civil cases, once it attaches, cannot be ousted by subsequent happenings or events. Yes, Article 185 of the Family Code is remedial in nature, and procedural statutes are ordinarily accorded a retrospective construction. However, they will not be so applied as to defeat procedural steps completed before their enactment. Issue 2 of 2, whether or not the petition for adoption should have been granted in favor of Zenaida only. Held, no. Although Dioscora Biles was not named as one of the petitioners in the petition for adoption filed by his wife, his affidavit of consent, attached to the petition as Annex B and expressly made an integral part thereof, shows that he himself actually joined his wife in adopting the child. The pertinent parts of his written consent read as follows. 2. That my wife, Zenaida Kotzebue-Biles, and I mutually desire to adopt as our child, a boy named Jason Condat, still a minor being 6 years old, likewise residing at 18C Imperial Street, Legazpi City, Albay, also in the Philippines. 3. That we are filing the corresponding petition for adoption of said minor child, Jason Condat, before the Juvenile and Domestic Relations Court, now the Regional Trial Court in Legazpi City, Albay in the Philippines. 4. That I, Dioscora Biles, as the husband and father, am giving my lawful consent to this adoption of said minor child, Jason Condat. 5. That further, my wife Zenado Kotzebobiles, and I have continuously reared and cared for this minor child, Jason Condat, since birth. 6. That as a result thereof, my wife and I have developed a kind of maternal and paternal love for the boy as our very own, exercising therein the care, concern and diligence of a good father toward him. 7. That I am executing this document, an affidavit of consent for whatever it is worth in the premises as to the matter of adoption of this minor child, Jason Condat, by my wife Zenado Kotzebobiles and by me, Dioscorus C. Bobiles, in any court of justice. The foregoing declarations, and his subsequent confirmatory testimony in open court, are sufficient to make him a co-petitioner, under the circumstances then obtaining, and by reason of his foreign residence. He must have yielded to the legal advice that an affidavit of consent on his part sufficed to make him a party to the petition. This is evident from the text of his affidavit. Punctiliousness in language and pedantry in the formal requirements should yield to and be eschewed in the higher considerations of substantial justice. The future of an innocent child must not be compromised by arbitrary insistence of rigid adherence to procedural rules on the form of pleading. Decision, petition denied.